For years, parents and psychologists have watched a disturbing trend unfold. Teenagers are sleeping less, and rates of depression are climbing. And the focal point of that anxiety has been the glowing screens in their hands. But whenever attempts were made to hold social media platforms legally accountable for those trends, prosecutors ran into a legal shield called Section 230 of the Communications Decency Act. Passed back in the early days of the internet, this law dictates that a tech company cannot be treated as the publisher of the information its users post. If someone shares harmful content on a platform, the platform itself is generally immune from the legal fallout. Because of that shield, suing tech giants over specific videos or images on their feeds is a proven legal dead end. To get a case into a courtroom, prosecutors realized they had to look past the posts and find a different vulnerability in how these companies actually operate. That search for a new target led directly to a federal courthouse in Oakland, California, where a bipartisan coalition of 29 state attorneys general has converged on Meta. Instead of arguing about user-generated content, these states are putting the underlying architecture of Facebook and Instagram on trial. They are arguing that the product design itself is the problem. The states claim that features like the infinite scroll and relentless push notifications are actually defective products, engineered specifically to hijack attention and foster compulsive use. The financial liability attached to the strategy is staggering. Meta has estimated that the theoretical damages in this case could reach $1.4 trillion, a figure roughly equal to the entire market value of the company. The states are seeking specific legal injunctions, hard-coded age restrictions, and the permanent deletion of any algorithms built using data collected from children. Rather than extracting a cash settlement for past behavior, the states are pursuing a court order to dismantle the core mechanisms of the attention economy. Meta's defense relies heavily on the public posture maintained by its leadership. Executives, including Mark Zuckerberg, have repeatedly claimed they prioritize user well-being and build their platforms to be safe. To pierce that defense, the states are weaponizing the company's own records. They have compiled internal communications showing that Meta employees were well aware their design choices were driving addictive behavior in younger users. Many of these documents became accessible to regulators after whistleblower leaks provided the specific internal data points and meeting notes prosecutors needed to bypass the company's public-facing claims. By comparing what Meta knew internally with what they said externally, the states are building a case for false marketing. They argue that misleading the public about safety violates state consumer protection laws. Proving deliberate deception transforms the narrative from an accidental byproduct of technology into a case of intentional, illegal exploitation of children. Overseeing this complex web of arguments is U.S. District Judge Yvonne Gonzalez-Rogers. She has structured this trial in a highly unusual way. An 8-person advisory jury will provide input on the evidence, but Judge Rogers alone retains the final authority to issue a ruling. And before opening statements were even delivered, Judge Rogers handed down a major ruling regarding federal privacy law, specifically the Children's Online Privacy Protection Act. She granted the states partial summary judgment on the issue, ruling as a matter of verified fact that Meta failed to meet the law's requirement to obtain verifiable parental consent before collecting data from children under 13. For Meta's legal team, this is a catastrophic early defeat. They are walking into the courtroom with a verified privacy violation already recorded against them, which strips away their ability to argue that they complied with basic child safety laws. This diagram maps the loop driving Meta's valuation. The recommendation algorithm is optimized to keep people scrolling, maximizing app time. That screen time directly creates ad inventory, scaling revenue. States demand the court intervene, forcing the algorithm to target well-being instead, breaking the loop. Executives who built these systems, like Instagram head Adam Mosseri, are expected to take the stand and justify the code they deployed. While a fine is just a temporary penalty, targeting the algorithm itself threatens to legally outlaw the mathematical equation that makes the company profitable. The Oakland trial sits at the center of a multi-district litigation, consolidating over 3,000 similar federal lawsuits from across the country. Meta isn't the only defendant caught in this web. Platforms like TikTok, along with Snapchat and even YouTube, are all facing identical accusations regarding their product design. As a bellwether trial, the judge's final ruling here acts as the legal blueprint for how thousands of other cases will be handled. For the past decade, the tech industry relied on addictive design to fuel massive financial growth, insulated by laws written before social media even existed. If the era of the infinite scroll comes to an end, it won't be because these companies developed a conscience. It will be because the justice system finally found the legal framework to outlaw it.